The broadcast is now starting. All attendees are in listen-only mode.
Hello, good afternoon, everyone. This is Sunny McCall speaking, Vice President of Content and Experience with Momentum, and we are delighted to have you with us today for our webinar session focused on an overview of the NSA's surveillance program and current legal challenges. I'm delighted to have with us two very seasoned industry experts in this regard, Joseph Moreno and Colleen Depman-Kukowski. Joe is Special Counsel in Cadwallader's White Collar Defense and Investigations Group, having formerly served as a federal prosecutor with the U.S. Department of Justice in the National Security Division and also with the U.S. Attorney's Office for the Eastern District of Virginia. Joining Joseph on the call, of course, is Colleen, an associate with Cadwallader, and also in the Washington office, where she focuses on white-collar criminal defense and corporate and organizational compliance. Before I go ahead and turn it over to Colleen, I just wanted to go over a few housekeeping remarks with you all who we have here with us today. One of them is that Joe and Colleen have been kind enough to make a copy of their slides available once the session has concluded. They will be sharing more information on their contact details and how you all can reach out to them. Additionally, this session is being recorded as well. So in case you would like to receive a copy of the recorded presentation after the session, we'd be delighted to hand that over to you as well. Finally, if you have any questions or comments for the speakers at the conclusion of the session, if you would just be so kind as to use your questions or chat bar and to send those to me. I'm actually listed on the system as my colleague, Matt Godson, but I would be happy to take and field those and then propose those to our speakers at the end of the session. Thank you so much, everyone, again, for your time. Looking forward to a great session here. And with that, Colleen, I'll now turn it over to you.
Thank you, Sunny, and thank you for everyone who's joining us today. It's kind of a dreary day out, so hopefully we'll give you something that liven up your afternoons. What Joe and I plan on doing today is kind of walking through the basics of FISA, which is the predominant foreign intelligence surveillance statute. How FISA came into existence, the nuts and bolts of how it works, and then we will delve into some of the reforms that came about after September 11th, most of which came out of the U.S. Patriot Act. After that, we're going to turn to something many of you are probably quite familiar with, which are the disclosures that Edward Snowden made last June about the National Security Agency's various surveillance programs and various other surveillance programs across the intelligence community. We'll discuss a little bit about those programs, how they work according to government documents that have been declassified. And then lastly, we'll look at some of the legal challenges. This is an area that is ripe for litigation, and indeed at the moment there are 3 rather pivotal cases within federal courts of appeals being litigated about whether or not the surveillance programs are legal and can continue. After that, we'll have a couple minutes left, hopefully, and we should be able to open it up to a Q&A for everyone there. So please, take note of anything you might want to ask us, and hopefully we can cover it at the end. So with that, I will turn it over to Joe, who will start walking us through FISA.
Thanks, Colleen, and thanks to everybody for dialing in. I hope this is helpful. So prior to the passage of the FISA surveillance, the Foreign Intelligence Surveillance Act, or FISA, in 1978, the government certainly did engage in warrantless electronic surveillance. It was generally accepted that this authority derived from the president's constitutional authority to conduct foreign affairs and in his wartime ability to protect the country's national security. So it was generally unchallenged to the extent that people were even aware of it. Typically, it would be authorized by the president and then sometimes through the attorney general. And to the extent that it was discovered and challenged, courts generally recognized an exception to the Fourth Amendment for national security when it comes to the collection of foreign intelligence. Now, there were some safeguards that courts did insist on when it came to domestic surveillance where there was no evidence of a foreign power. And the sort of seminal case in that area is often referred to in this realm as the Keith case. And the Keith case was a 1972 Supreme Court case in which a U.S. citizen was being surveilled and was arrested for bombing a CIA building based in Michigan in the United States. And the government argued that the warrantless wiretapping of the suspect prior to arrest was constitutional because there should be a carve-out of the Fourth Amendment protection for national security. The Supreme Court said, you know, we're not willing to go that far because we don't see any foreign intelligence aspect here. This is a domestic individual, a U.S. person who bombed a U.S., a federal CIA facility, but there's no indication that he was acting on behalf of a foreign power or in collaboration with a foreign terrorist group. So the Supreme Court would not go so far in the Keith case to provide a carve-out for domestic surveillance in the absence of foreign intelligence information. But the court did say in dicta, we strongly urge the Congress to provide a solution to sort of create a framework applicable to electronic surveillance conducted for national security purposes in the United States. So shortly after the Keith case, there also came revelations in the mid-70s that the United States for quite a while had abused its warrantless surveillance powers. And the line between surveillance for national security to detect foreign intelligence had kind of blurred and was often being used to conduct surveillance of U.S. domestic citizens for purposes that have little or nothing to do with national security. And the Church Committee, which ran for about 2 years, unveiled a number of really shocking revelations that people had not previously been largely aware of. That there were wiretapping of prominent Americans going back to the 60s, such as Martin Luther King and Jimmy Hoffa. That in the Watergate era, President Nixon had used the Central Intelligence Agency to spy on political enemies. Again, there's no indication that these were legitimate foreign intelligence, counterintelligence, or counterterrorism investigations. These were simply using foreign surveillance powers of the United States on domestic targets. Army intelligence had been used for years to infiltrate civil rights and anti-war groups. That came out, as well as a program that had been conducted for years by the FBI, which was basically conducting surveillance of domestic political groups under the guise of national security, but with no real national security undermining for those activities. It was really just a subterfuge for what they were doing. So the culmination of the Keith case and the Church Committee revelations led to enactment of the Foreign Intelligence Surveillance Act. So around 1976, former Senator Ted Kennedy of Massachusetts worked with the Ford administration to start drafting the FISA statute. In 1978, by that time it was President Carter signed the FISA statute, which now provided a framework to say, okay, here's a mechanism for which investigators can obtain some sort of a warrant system, some sort of due process requirements before a court with judicial review that would say, yes, there is a standard by which we will authorize surveillance for national security purposes. Now, I would say that just to keep things kind of in our wheelhouse, we're not talking about foreign surveillance here. We're talking about surveillance within the United States. And we're making a distinction between law enforcement purpose surveillance and surveillance to conduct national security investigations to look for foreign intelligence. So there's a couple of requirements that are set forth in the FISA statute before you can get a warrant to conduct electronic surveillance. Okay. The target entity must be a foreign power or an agent of a foreign power. And I'll get into in a minute what these terms of art mean. The purpose of the surveillance must be to obtain foreign intelligence information. And I'll add to that bullet on the slide in that a further requirement is that that foreign intelligence information could not be otherwise obtained by normal investigative techniques. And the statute, which has been around for a while, obviously back then, phone wiretaps were really the preeminent use of this statute. Now, of course, we get into technology like email, instant messaging, and other forms of technology. But in addition to electronic surveillance, FISA also provides a mechanism for obtaining physical search authority and the use of things like pen registers and trap and trace devices, which are basically metadata trackers to record the telephone numbers called or received, respectively, from a telephone line. So not the calls themselves in certain cases, but just the numbers that are called. So what is a foreign power? A foreign power is, first off, a foreign government or a component of a foreign government, or an entity controlled by a foreign government, such as a political party. So if you have an individual that's acting at the behest of a foreign power, this could apply. It also involves designated terrorist groups, and there are generally two types. There are foreign terrorist organizations, or FTOs, that are designated by the Justice Department and Treasury, and those are groups like Al-Qaeda, Al-Shabaab, Hezbollah, and Hamas, as well as groups from all over the world, such as Shining Path and the IRA and things like that. It also includes specially designated global terrorists, which are groups, not individuals, individuals and groups are SDGTs designated by OFAC over at the Treasury Department. So any of these entities or individuals can constitute a foreign power. The second element is that the target of the surveillance has to be an agent of a foreign power. This means that it could be non-U.S. persons locating in the United States on behalf of one of those states or groups or terrorist individuals that we just mentioned, or U.S. persons, which are U.S. citizens and people living here lawfully in the United States, who engage in international terrorism activities or gather intelligence for a foreign power. So the trigger, the standard for obtaining surveillance of a U.S. person is a bit higher. There's an intent requirement, so that in order to get a warrant, the government must show that the U.S. person knowingly acted on behalf of a foreign power. There are also First Amendment protections for U.S. persons, and there are minimization techniques that are required, so that if surveillance is approved for a U.S. person, there are certain steps that must be taken to minimize the ancillary communications, basically the communications that have nothing to do with what the government is looking for. So these extra protections, such as this intent requirement, are not available for non-U.S. persons. So there's a bit of an additional protection here if the target the government is seeking to surveil on is a U.S. citizen or lawful resident. The FISA Act, at the same time as it created this structure, created two courts in which to provide some process for which the government could approach and seek FISA surveillance warrants. The one that is most often talked about is the FISC, the Foreign Intelligence Surveillance Court, and it consists of 11 district court judges appointed by the Chief Justice of the Supreme Court of the United States. And the FISC sits here in Washington, D.C., in an undisclosed location, and basically all that it does is it hears petitions for FISA warrants that are presented by the National Security Division within the Department of Justice. And within NSD, there's an office called the Office of Intelligence, and that contains attorneys, and their primary job is to present warrant applications to the FISC. They work hand in hand with the FBI and a group over there called the National Security Law Branch, which works on preparing FISA warrant applications and then presenting them to the FISC. There's also a secondary court called the Foreign Intelligence Surveillance Court of Review, or the FISCR. The Surveillance Court of Review actually never met until about 2002, and it hears appeals in the event that a FISC ruling is challenged. That's pretty unusual because the process involved in applying for a warrant before the FISC is entirely a one-sided process. There's only a government attorney that's present, and there's a judge that's present. There's no defense counsel. This is done entirely ex parte and in camera. So it's sort of difficult for a warrant to fail unless there are some serious problems, in which case the government can go back and seek additional support for its warrant application. So suffice to say, there have been very few FISC requests that have been denied over the years, very few. At the same time, the number of FISA warrant applications each year has greatly increased since September 11th attacks. Prior to September 11th, the average was about 600 applications per year. Since then, it has tripled to nearly 1,700 per year. So the FISC is a rather busy court with its 11 judges hearing warrants all the time. So the standard for obtaining a FISA warrant is different than the one that many of us as attorneys are most likely more accustomed to. So in order to get an electronic surveillance authority, or typically a wiretap, at the federal level, you look at Title III of the Crime Control Act, the so-called T3 wiretap. And so a T3 wiretap is what we typically think of when an FBI agent swears out an affidavit and goes to a district court judge, not a magistrate. For electronic surveillance, you have to go to a district court judge, and it tries to establish that there's probable cause. And that probable cause standard is fairly easy to meet. Basically, the affidavit has to describe the facts and circumstances showing that a serious crime has been, is being, or is about to be committed. And the judge will approve the warrant application if the standard is met, that there is probable cause that a crime was, is, or will be committed, and that the location that the government is seeking to monitor will be used to communicate about the crime. This is a fairly open process, and obviously, after the fact, defense counsel can attack this process, and they can seek to break down the argument that there was sufficient probable cause in the first place. And as we know, that can lead to after-the-fact suppression of evidence, and it can lead to really making a government's case a lot more difficult. So it's a process that keeps the government on its toes, if you would, because it really means that you have both the scrutiny of the judge in the first instance and then the defense later on to make sure that the probable cause was legitimate. At the same time, the target of a Title III surveillance warrant must be notified within 90 days. So at some point, you have to inform he or she they're being surveilled. At that point, they're usually arrested. But there is this process that even beyond the initial probable cause determination, at some point you have to loop the person in that they're being surveilled. Now let's look at the FISA application process. So there is a probable cause standard, but it's a bit different. And the process for preparing and submitting a FISA warrant is quite a bit more comprehensive than that of a Title III warrant application. First off, a FISA warrant, as mentioned before, is worked between the FBI and the National Security Division's Office of Intelligence in an entirely classified application process. Each FISA warrant has to go up the chain through the Assistant Attorney General for National Security all the way up to the Attorney General. So all those hundreds of FISA warrant applications that were mentioned earlier all have to be personally approved by the Attorney General before they can be moved forward. Now, the probable cause here is not that a crime is, was, or will be committed, but that the target that the government is seeking to surveil is a foreign power or an agent of a foreign power, and that the facilities targeted, meaning the phone line or the email account, whatever else the target is, will be used by that foreign power to communicate about this foreign intelligence information. There is no notification requirement to the target at any point, and the surveillance of a foreign power can go up to a year, whereas an agent, meaning an individual of a foreign power, can go for up to 90 days, both of which are certainly extendable by further application to the FISC. Since 1979, the statistic as of last year is that nearly 34,000 warrant applications have been submitted to the FISC over time, and only 11 in that time have been denied. So this bifurcated process of having intelligence information and a FISA warrant process versus a criminal warrant process really underlies the difference here, and the conceptual difference between the purpose of a criminal investigation versus an intelligence investigation. So criminal investigations are what we think of when we think of the FBI or the DEA or the police, collect evidence, arrest suspects, and secure convictions. And they bring this evidence into open court, and the evidence they rely on are wiretaps, such as the Title III warrants we talked about, physical searches of premises, collection of documents, and other third-party records through the subpoena power. It's conducted by law enforcement agencies like the FBI, the DEA, the ATF, and other local law enforcement and state and federal law enforcement agencies. Now, intelligence investigations are different. They don't seek to obtain convictions, and they never have any incentive to bring information into court. their incentive at the CIA and the NSA and the FBI, to the extent that it's an intelligence organization, is to detect and disrupt foreign threats to U.S. national security. So the factors behind the actions they take are not driven by the need to bring evidence into court. It's evidence that's reliable and that will allow them to prevent terrorist attacks. So they look at human sources, electronic surveillance, covert physical searches, like those obtained through FISA, and obtaining third-party records through something called national security letters, which are basically administrative subpoenas that the FBI are allowed to execute. And these activities, intelligence investigations, are conducted by what we think of as the intelligence community. So it's the FBI, CIA, Defense Department components, and others in that community. So subsequent to the FISA statute enacted in 1978, over the next few decades, a number of procedures were sort of gradually developed, and they became known as what was sort of known in the vernacular of the national security community as the FISA wall. And it's really under debate about when this wall was sort of created, but it seems to have been built sometime in the 80s and definitely by the mid-90s. What the FISA wall consisted of was a number of judicial decisions, but more importantly, Department of Justice procedures, which started putting into place safeguards to prevent the abuses that took place in the 60s and 70s, where domestic surveillance activities were being conducted under the guise of foreign intelligence investigations. So they started creating this wall to say basically investigators at the FBI, intelligence collectors at military intelligence and the CIA, they really should not be overlapping with criminal investigators that are trying to build cases and gather evidence that they're going to go to court. And the idea was a worthwhile one. It was really to protect and respect the individual civil liberties of the American public, to make sure that these abuses did not continue. The problem was that it went a little too far, and you had a point where intelligence collectors would, the hurdles in order to get authorization to share information from the intelligence side to the criminal side were so onerous that the FBI and the rest of the intelligence community said, you know what, it's just not worth it. There were so many hoops to jump through, and the levels of approval were so high that it effectively created an absolute wall between the two processes, even to the point where you had FBI agents on the intelligence gathering side not talking to FBI agents on the criminal investigation side about the same target. So they could be investigating the same group or the same people, and they would not be coordinating or even communicating with each other. So you had a serious information sharing gap. And in many circles, the attacks on September 11th are blamed, at least in part, on the fact that maybe had there been some intelligence sharing within the FBI and certainly between the intelligence community and law enforcement, there may have been some information that could have been shared, and if it was in the right hands, it may have helped disrupt or prevent the attacks. So you had this wall that really created this chilling effect that effectively said no sharing between intelligence gathering and criminal law enforcement. So after September 11th, everyone became aware of this wall that had gradually been built through no real legal necessity other than these self-imposed rules that were adopted by the Department of Justice. So Congress passed almost unanimously a month after the September 11th attacks the USA Patriot Act. And the Patriot Act did a number of things, but the most prominent it did was it effectively tore down this wall and said law enforcement absolutely should be talking to the intelligence community and the military. It should be sharing information, and we should not be tying our hands behind our back unnecessarily. So the wall was torn down, and it sounds great, and it sounds easy. In fact, it's created a tremendous amount of difficulty in litigation about how to properly combine two very different missions, the preventive mission of intelligence gathering and the post-act arrest and conviction mission of criminal law enforcement. So it's been a bit of a struggle over the past 13 years, but it has been happening. At the same time, the Patriot Act added a number of other reforms, including bulking up surveillance laws to reflect new technologies, adding new money laundering crimes to the government's arsenal, and enhancing penalties for various terrorism-related crimes. There's a couple of provisions that I'll mention that the Patriot Act passed that are, again, also part of the vernacular of the national security community, the wall being one that people know. Another one is Section 215. Section 215 of the Patriot Act created what's referred to as the business records provision. Basically, it allows the FBI to seek a court order directing the production of records or other documents when there are reasonable grounds to believe the information is relevant to a terrorism investigation. Now, the standard here is pretty low, and this is done through the FISA process, which means that when the FBI seeks this order from the FISC, it's classified in ex parte, so there's no way to challenge it. So between the low standard of what is relevant, not even probable cause, and the fact that it's done completely in a classified manner, it's gotten some controversy over the fact that the FBI has this ability to run with these searches and obtain this information in a process that's almost entirely without judicial oversight other than the FISC and anyone's inability to challenge it. What they're seeking under Section 215 under business records is not the content of calls or emails, it's metadata, and it's the fact that calls are made, the numbers that are dialed or received, the amount of time that the call lasts, and the fact that emails are sent and received. So it doesn't sound too controversial, but when I turn it over to Colleen, you'll see that Section 215 has become the basis for some pretty controversial government surveillance programs that are now being scrutinized. The next slide indicates another important post-September 11th reform, which was the enactment of Section 702 of FISA. 702 says, and I started off by saying that FISA focuses on domestic surveillance, and historically that's what it did. What 702 allowed the government to do, starting about 6 years ago, was to conduct surveillance outside the United States. Now, off the bat, this sounds fine, right? Why do we care? Why are we upset about outside the U.S. surveillance? Well, the problem is that while the target is outside the United States, who that target is corresponding to may very well be inside the United States. And we'll also see, as some of these revelations of these programs have emerged, that Section 702 has been used as the basis for conducting a lot of domestic surveillance under the guise that, well, the target's overseas, that's who we're focused on, but if we happen to capture communications with people inside the United States, well, so be it. Meanwhile, those protections we talked about when the target is a U.S. person are not being followed because the target is a person outside the United States. So the Section 702 is the justification for a program called PRISM, which we'll talk about in just a moment, and some other somewhat controversial NSA surveillance programs that, again, arose from something that did not seem nefarious, but has been used in ways that some people have been critical of. At the same time, these FISA amendments in 2008 also provided telecommunications companies with immunity for cooperating with intelligence collectors, which has also been controversial because basically it says that providers like AT&T and Verizon cannot be held civilly liable for voluntarily cooperating with the FBI and the NSA and other intelligence collection agencies. And I would be remiss without mentioning one more national security document, which is extremely important, Executive Order 12333, which is often mentioned. It was actually issued by President Reagan way back in 1981, and it's been amended many times, but it remains the basis for a lot of the post-Watergate reforms and basically telling the different intelligence agencies what they could and could not do as opposed to what law enforcement could do. So basically defining the lanes in which the CIA, the Defense Department, and the FBI should be operating in. And Executive Order 12333 is still cited quite a bit even today as the basis for certain activities by the government, some of which have come under some criticism. So with that, I'm going to kind of fast forward to some of the revelations that have taken place in the last few years that have led to a lot of the controversy and litigation that we're seeing today. And with that, I'm going to pass it over to my colleague, Colleen.
Thanks, Jeff. Many of you will be familiar with these revelations. Starting last June, the Guardian newspaper, which is based out in the UK, began publishing several highly classified documents that were obtained at the time from an unknown source relating to surveillance activities that the NSA and other members of the intelligence community were undertaking. Soon after The Guardian began publishing these disclosures and these documents, the New York Times and the Washington Post also began publishing various documents as well. Several days later, on June 9th, Edward Snowden revealed himself as the source of these leaks to The Guardian and to the Post and the Times. Snowden himself was an employee not with NSA, but with the defense consulting firm Booz Hamilton, who works with just about every entity within the intelligence community. Snowden was based out in Hawaii, and he worked as a systems administrator for NSA, which means he himself wasn't actually using and analyzing the intelligence that these programs were collecting. He was setting up the technology underlying them, helping users, the various clients within the intelligence communities actually access the programs, and operate them. So obviously this created quite a stir once he revealed himself, and the government quickly acted and indicted him just 2 weeks later with espionage. As you all likely recall, there was a bit of a cat and mouse chase with Snowden around the globe. He soon revealed himself to be in Hong Kong, did not stay in Hong Kong for long, and eventually found himself seeking amnesty in Russia, of all places. Russia did indeed grant him a temporary safe haven there, which has been renewed several times, most recently this past August for another 3 years. So as far as everyone is concerned, he is still living at large there, and as you've all likely seen, continues to give interviews with various media publications. He does webinars and is still quite outspoken. In terms of what Snowden actually revealed, there's a lot of misinformation out there about the programs, a lot of conjecturing and the like. So we're going to focus on the documents that he revealed. First and foremost, and this is what The Guardian first published, was a top secret order by the FISC, which was delivered to Verizon Business Services, mandating that it hand over all the call records of its customers. So this goes back to what Joe was discussing earlier, and so what the order to Verizon Business Services was asking for was all the telephone metadata. So not the content of the calls itself, but the records regarding what phone numbers called what other phone numbers at what time and for what duration. Shortly after that, The Guardian and the Washington Post jointly published a PowerPoint presentation detailing the NSA's collection of digital information, emails and the like, from various internet service operators as part of a program known as PRISM. The 9 firms that were entailed there were the biggest internet service operators you can think of, Hotmail, Google, Yahoo, Facebook, YouTube, Skype, AOL, and Apple, along with Paltalk. And so much like the FISC order to Verizon Business Services, here what they were still seeking is metadata. So what that is for emails is essentially the header information. Again, any copies or blind copies when it's sent, and often the email subject itself, but not the content of the email. In addition to these documents, there was a highly controversial list of world leaders that was published and discussing and detailing the types of surveillance efforts the U.S. government was undertaking regarding them. And this generated quite a bit of controversy because in addition to the various alleged bad guys running around in the world, and included many allies on the list. Angela Merkel in Germany was on it, and she, of course, is one of the chief allies of the U.S. government, and so that created quite a stir there. So in response to Snowden's allegations, DOJ and NSA, in addition to very quickly indicting Snowden for his disclosures and trying to halt further disclosure of classified information, started their own campaign of declassifying information just to be able to respond to what was immediately a national and international dialogue regarding U.S. surveillance activities. One could say they took rather uncharted steps for the U.S. government and that they took a swath of FISC orders and declassified them, along with a white paper that the Department of Justice authored, which walked through step-by-step Section 215 that Joe spoke of earlier, and how Section 215 was the basis and authorized this vast bulk collection of telephone metadata. And that's really what we're going to focus on now, just because the government documents that have been officially declassified really kind of walk us through that process step by step.
You know, one thing I'll just add before we go on to the next slide is that at this point, when this FISC order was declassified, first leaked and then declassified, at this point, a FISA warrant application and a FISA order had really never been released publicly. So even when FISA-derived information would be brought to a criminal trial, it would be done in completely ex parte and in camera. So the judge might see it, but the defense would never be able to attack the underlying warrant or the underlying probable cause determination that the government made to the FISC. The judge would make that determination and decide solely if the evidence could be included or not. So this really was the first time, and just a couple of years ago now, that the public saw some of the inner workings of the FISA court. And the litigation that followed of the Verizon order here in the District of Columbia was the first time that a district court examined a FISC program and made a judgment on FISC-based materials.
All right. So moving on, what was this program? So like I said, we're going to focus on the order that was sent to Verizon for all what is formally termed telephony metadata. Again, this is the call, the numbers dialed, the duration of the calls, and the times of the calls, not the content. As Joe explained earlier, this authorization under the FISC is solely for foreign intelligence and counterterrorism investigations, and the FISC orders strictly impose limits on querying this bulk data collection for anything else. So the way the FISC order operated, the U.S. government is authorized to query, and by that I mean search, this bulk data that it had been collecting from Verizon and presumably other similar phone carriers. And it was only able to search this data once it had an identifier. What an identifier is in layman's terms is simply a telephone number that is associated with a foreign terrorist organization or agent. This is also referred to as a seed. So in order to use that seed, there must be a reasonable articulable suspicion, which will sound familiar to any criminal attorneys in the audience here, that the seed was associated with someone for either a particular foreign terrorist organization or an agent thereof. So what this means, practically speaking, let's say the FBI or someone else within the intelligence community has a source, and that source comes forward and says, hey, look, I know Colleen Kukowski. She just came back from a trip overseas and is bragging about how she was in Syria, made a trip to an ISIS training camp. Here's her telephone number. So then what the intelligence community will do is say, all right, let's take Colleen's telephone number, this seed, and query it against this database. So what they will see then, once they take that query, is all the telephone numbers that I've dialed from that, and then in turn, the second tier contacts. So let's say Colleen Kukowski dials Joe Marino. They will also then see who Joe Marino dials, and then the third tier contacts. So Joe Marino dials Tom. Tom then dials Pam. They'll see those connections. What this is important for is, say, like I said, they suspect that I, Colleen, am affiliated with or could potentially be affiliated with ISIS. I call Joe. The U.S. government has no idea who Joe is or what he's doing, but they see his telephone number. What they then see by being able to look at the second and third tier contacts is, well, hey, we don't know Joe, but Joe also called this another person, Tom, and Tom, we know, is also affiliated with ISIS. So now they have cause to look at Joe and say, hey, is Joe this missing link in a potential conspiracy? As Joe mentioned, there's important, safety precautions and limitations built into this whole process. So under my hypothetical, the U.S. government is looking at my phone number because a source came in and said, Colleen told me she just got back from a Syrian training camp. If the source came in and said, Colleen attends a mosque that several other Syrians who I think are bad guys came in, the government could not act upon that alone because it's protected by the First Amendment. So moving forward, as we all know, there is quite a large dialogue ongoing. President Obama has, and the intelligence community has been addressing various reforms, and included among those are now, instead of getting 3 tiers of contact information, Colleen, Joe, Tom, Pam, they're getting just first and second tiers. So Colleen calls Tom, or Colleen calls Joe and Tom instead of Colleen calls Joe, Joe calls Tom, Tom calls Pam. Various new positions have been created at the NSA. President Obama now has his own task force looking at the program, studying what sort of reforms can be adopted. But as you would expect, many civil liberties advocates are not quite satisfied with that, and thus began the onslaught of litigation. And I apologize, I know we're running up on time, so I'm going to walk through these 3 main cases that we should all focus on rather quickly, and if you have any questions, please do ask. The first case that we're going to look at is Clayman v. Obama. This was filed within the District of Columbia last year, and it was led by Larry Clayman, who is a rather notorious conservative activist known for his very flamboyant style. However, he has been accompanied by several friends of the court, Amici, the ACLU, and the EFF, who have been also presenting the arguments in this case. And essentially what they argued was that the bulk collection of data under Section 215 violated their constitutional rights under the First, Fourth, and Fifth Amendments. In a rather shocking opinion, just based upon the strident language he used in it, Judge Leon of the District of Columbia ruled on behalf of the plaintiffs and said that the NSA program most likely does violate the Fourth Amendment against unlawful searches and seizures. And you can see here he used quite vivid language, saying he could not imagine a more indiscriminate and arbitrary invasion than the bulk data collection programs. What Judge Leon did then was issued an injunction saying that the NSA and the federal government did indeed need to stop collecting this information and purge what data they have. But he stayed that injunction pending what would be the obvious government appeal of it. Oral arguments were held on this in the D.C. Circuit just last month, so we are waiting to see how the D.C. Circuit comes out. Key issues in the oral arguments were, do the plaintiffs have standing? So were they in fact injured by this? What constitutes a search? Did the unlawful search happen when the bulk data collection occurred, or does the unlawful search happen when the bulk data is actually queried? And then finally, does the case Smith v. Maryland apply, which is an older case that essentially says pen registers and trap and traces, which Joe discussed earlier, which acquire only telephone metadata, the numbers dialed and the duration and the time, do not require Fourth Amendment warrants. The second case that is ongoing is in the Southern District of New York and now the Second Circuit. The ACLU filed it, making essentially the same arguments that Larry Clayman did. And in contrast to Judge Leon in the D.C. Circuit, 2 weeks after Judge Leon issued his opinion, Judge William Pauley in the Southern District of New York held that the telephone metadata collection under 215 was indeed lawful. So essentially reached the completely opposite opinion that Judge Leon did, and he granted the government's motion to dismiss. Unlike Judge Leon, Judge Pauley applied Smith v. Maryland and said that these are the same things, just because a number was dialed on a telephone, and the metadata from that, which was the issue in Smith v. Maryland, is no different than numbers being dialed via cell phones, even though cell phones are a far more indispensable portion of people's lives these days. So much like the U.S. government, the ACLU immediately appealed that ruling, and oral arguments were held on that in the Second Circuit last month as well. The third and final case that's ongoing is it was in the District of Idaho, and now it's in the Ninth Circuit. In this case, unlike the other two, which featured relatively heavy-hitting legal figures, a nurse and her husband, acting as her lawyer, filed suit against the government, again claiming that the bulk collection of metadata violated their Fourth Amendment rights. Judge Lynn Windmill granted the government's motion to dismiss because it said, again, Smith v. Maryland controlled here, and phone metadata collection does not require a warrant. That said, Judge Windmill did so quite begrudgingly, if you read his opinion. He did not take the steps that Judge Leon did in saying that Smith was no longer controlling, but at the same time he said that Judge Leon's opinion, which essentially said that Smith is outdated, could serve as a blueprint for a Supreme Court case. And indeed, he invoked Judge Sonia Sotomayor's statement in a recent Supreme Court case that said Smith itself was ill-suited to the digital age. The oral arguments in Smith v. Obama actually happened yesterday, so right now we're in a holding pattern to see where these three different appellate courts come out. And many would say, and I would agree, that there's a large chance this issue could reach the Supreme Court, particularly if the appellate courts continue to issue conflicting rulings. With that quick sprint through the last three cases, I apologize. I think we'll turn it over to you all if anyone has any questions.
Thank you so much, Colleen and Joe. That was excellent, very informative, and we actually did have some questions come in, so I'll go ahead and jump right into those. The first question is, will Riley v. California have an impact on the bulk telephony program under Section 215?
I will admit I'm not as familiar with it. I think what will end up having an impact at the moment is whether or not these three cases continue to have conflicting rulings, and then the government will go from there, and whoever, I suppose, ends up with the short end of the stick is going to be appealing to the Supreme Court, and I think that's where it will come out. What's interesting with these three cases is that they're looking mostly at the constitutional challenges to bulk collection under 215 and not focusing as much on the reasonableness of the government's interpretation of 215. So whether or not the Section 215 does indeed authorize this bulk collection is an issue that's being raised within oral arguments in these cases, but not being looked at or scrutinized as much in the briefings.
Thank you, Colleen. Another question for you. What reforms, if any, has Congress enacted to address civil liberties concerns?
So, which may not come as much of a surprise to anyone with our given Congress, but they have not enacted anything at the moment. There have been several bills that have been floated and that are in the working stages, but nothing has been passed at this point. And to some degree, that's a bit surprising because this is something that, while the court process is drawn out and is going to take quite some time to resolve itself and potentially make its way to the Supreme Court, Congress itself could very quickly act and repeal Section 215, amend it, put in specific exemptions and the like. But at this point, anything is still in draft proposal stage.
Yeah, I would just add to it, as Colleen said, I mean, basically, the proposals have ranged from anywhere from sort of, scaling back to completely canceling, completely preventing bulk collection processes by the NSA, which has been pushed by Senator Leahy. But as Colleen said, I mean, Congress has just been sort of in a stalemate and has not enacted anything with any kind of teeth in the last few years.
Well, thank you so much for that, Joe and Colleen. This has been a wonderful session. I'm sure all of our participants today have greatly enjoyed your presentation. For those of you who are there still with us, you see Joe and Colleen's contact details, phone number, and email. Please do feel free to reach out and engage with them directly. And before we close out, Joe and Colleen, any closing remarks for the participants?
None for me other than just to say thank you for tuning in to us.
Yeah, thank you as well. I mean, it's an interesting area, and really I think in the next few months we're going to see some pretty interesting developments in litigation, and hopefully with the new Congress perhaps some reforms that'll sort of, better define what the government is allowed to do, what it's not allowed to do, and really kind of restore some confidence because American industry has suffered a bit from these revelations with the idea that American companies are sort of in bed with the NSA, and therefore things like cloud computing in the U.S. are not secure. And so companies like Microsoft and Google are losing business as a result. So it's a real hope that the administration and Congress can work together and firm up the protections and make it clear what the government is and is not doing.
Well, Joe and Colleen, thank you again so much for the presentation. It's been lovely to be here with you both today, and thank you so much for all of our attendees who logged in. And we'll just look forward to hearing more from you, Joe and Colleen, on this subject, and keeping our ears tuned to the development of issues. Thank you so much, everyone, and have a good rest of your day or afternoon. Bye-bye.